Thank you very much, Jenna, and welcome everyone today. We're here to talk today about severance, but unfortunately not the severance that comes with eerie hallways and corporate conspiracies. Our severance today involves slightly fewer existential crises than the Severance TV show, but only slightly. There'll still be plenty of tense moments and emotional unravelling, just about the same amount of paperwork, and depending on the parties involved, just as much drama. Instead of working for a dodgy corporation, you just co-own a house with your ex. So today, instead of splitting consciousness, we'll be splitting the garage. Our co-owners can hold property as joint tenants or tenants in common. And that property can be real or personal property that can be held in either of those ways. A tenant in common is a manner of holding property involving an undivided fixed share. It's not a physical division, but it is a distinct share which could be passed under the person's will or under intestacy if they don't have a will. By contrast, joint tenancy is characterised by a right of survivorship because the joint tenants own the whole of the property. So if one of them dies, the other one continues to hold the whole of the property. And that is called by right of survivorship. There are also the four unities, which are time, possession, title, and interest, which are required for a joint tenancy. So time involves the joint tenants having their interests vest at the same time. The interest unity is that the joint tenants are wholly entitled to the whole of the property. Possession unity is requiring that each tenant has just as much entitlement to possession as the other joint tenants. And that is also something that must coexist where we have tenants in common as well. And then finally, the unity of title requires that the joint tenant's title is derived from the same document or act. And where we have a destruction of any of these four unities, except for possession, it will sever that jointure. So in terms of the right of survivorship, again, our joint tenants are entitled to the whole of the property. And that interest would pass as a sole proprietorship if the other remaining joint tenant were to die. And situations of comorientes, where we have multiple deaths of joint tenants and we don't know who died in what order, then there are two different ways that this can be resolved in New South Wales, the Northern Territory, Queensland, Tasmania, Victoria. The elder of the joint tenants is taken to have died first, whereas in the Australian Capital Territory, South Australia since January this year, and Western Australia, it's as if the property is owned as tenants in common as at death. So moving on to severing joint tenancies. So the system of title that we deal with is Torrens title, and that involves indefeasibility, which means that ownership's established by registration on the land register. And of course, a registered interest has priority over an unregistered interest. We can sever a joint tenancy either at law or in equity. At law, we're dealing with the registration by the registry of an instrument of severance. In equity, we have three ways in which we can sever a joint tenancy that we'll be looking at in detail now. Firstly, a mutual agreement between the joint tenants. Secondly, where there's a course of dealings or conduct that's sufficient to establish interests in land, where the joint tenants are treating it as a tenancy in common. So there's a course of dealings where the conduct of the joint tenants is inconsistent with there being anything other than a tenancy in common. And finally, unilateral severance. So our first equitable severance of joint tenancy is mutual agreement. So this can be an express or implied agreement. In the case of Calabrese and Mauricio, we have an agreement to sever a joint bank account, which was unperformed at the time of death. So the bank account had not been severed. The agreement itself dealt with some other matters, and it included the agreement was subject to a condition subsequent, and that condition subsequent failed. The court found that even though there was a condition subsequent that failed, the agreement itself had caused a severance in the joint tenancy because the parties had agreed how the property should be dealt with, and therefore it was effective. Even though there were other matters that were the subject of the agreement that couldn't be completed. Looking into mutual agreements in greater detail, we have the Sprott and Harper case, where we have our first husband and wife who own their home as joint tenants, and they've become separated. The wife left the home, and the husband and wife have commenced negotiations for property settlement orders. They then go off themselves, made an agreement without their solicitors. They wrote down the value of the house, the value of the mortgage, the value of the other assets, divided it in half, and had that the wife would be paid a certain amount, including a sum in relation to her share of the house. And if that amount wasn't paid, then the house would be sold. So this was the subject of their agreement between them. They then went to their solicitors, who commenced negotiations to convert this agreement into property settlement orders. And during that time, the wife tried to increase her share of what she would get from that marital pool. The husband rejected that attempt to increase her share and insisted on the terms of the agreement. The wife then died. The wife's legal personal representative tried to argue that the agreement between the couple had severed the joint tenancy. The husband said, no, they were still negotiating. There was no severance of the joint tenancy. The parties hadn't even considered severing the joint tenancy. So the Court of Appeal in this matter said, well, actually you can sever a joint tenancy without even knowing what joint tenancy is or what severance is, because the actual question that the court looks at is, did the couple act in a way that was inconsistent with the maintenance of a joint tenancy? So the husband had said, well, you know, the wife had unsuccessfully attempted to bury the agreement, therefore, you know, there's nothing final here. And the court says, well, yes, the fact that she unsuccessfully attempted to bury the agreement and he stuck to the agreement, it didn't change the fact that they were dealing with an agreement that indicated both parties had a clear intention to sever the joint tenancy. And there was no basis for the court to infer that that wouldn't be effective until there were consent orders. That wasn't a condition of the agreement, that there was no severance or that the agreement wasn't legally effective until consent orders were in place. Our next husband and wife are Fernando and Elizabeth Maskey, and they have a joint do-it-yourself will, which of course we know usually ends in tears. Or it's actually very good when our clients go and do it-yourself wills, because we tend to make a lot of money off that, because we very rarely ever see one that's been completed properly. Now here, the husband and wife owned their property as tenants in common, but their joint will provided that the survivor of them would live in the house and handle all monies, and that when they both died, all the possessions would be sold and half would go to the wife's daughter and half to the husband's children. And the husband dies, and the home's, of course, in joint tenancy, and the wife says, well, the home's mine, but the son sued for a declaration that it was a mutual will and that the joint tenancy had been severed by that mutual will and had created a life estate for the wife. And the court agreed. The court agreed. I think I'm not on the wrong page there. Anyway, the court agreed, but it said that the joint will itself didn't sever the joint tenancy. The will evidenced an agreement to dispose of the joint tenancy property in a way inconsistent with joint tenancy and then creating the life estate. But the joint will itself doesn't sever the joint tenancy. It was more that they were able to look at the conduct of the parties and their intentions in that document, rather than the will itself being a legal instrument that severed the joint tenancy is probably the best way to put it. The Court of Appeal upheld this this finding of the lower court. So we have another case in which we have a joint tenancy that's been severed. Okay, our next, so that is mutual agreement. So moving on to course of dealing. So this is where the court is looking at conduct of a course of dealing. So we don't have an express or implied agreement here. We have something else, and the court's going to be looking at, is this something else going to be enough to cause a severance in the joint tenancy? Firstly, we start with a presumption that where you have a joint tenancy at law, there's a presumption that there's a joint tenancy in equity. And this is a rebuttable presumption. It'll be displaced by conduct of course or dealings involving express or implied words of severance. So this is not an express or implied agreement, but it's express or implied words indicating severance. We have an absence of the three of the unities, or one of the unities, absence of unity, time, interest, or title. So remember, possession can be something that, well, possession is something that tenants in common have as well. So the absence of unity of possession is not compelling. Then we have where contributions to the purchase price or contributions to renovations to the property are unequal. And there is a presumption that the parties intend to take distinct proportionate shares. It's not always a presumption, of course, when we're dealing with married couples, but you'll come across circumstances. I had one where mum contributed 100% but put the property in as joint tenants with her son and daughter-in-law, and then everything turned to hell, and the argument was that she's entitled to that. She contributed the money, so in equity, even at law, she was only, if the joint tenancy is severed, she is legally looking at a third, but she contributed 100%. So there was an argument in equity that she's entitled to that contribution proportionately. And finally, commercial partners are presumed to take in distinct shares. So looking at some examples of cases where the courts had to look at the conduct of the parties, we'll start with a Tawantin property where we have John Headkey and Joseph Wilk, who are joint tenants. We don't know what their relationship was, but they do own a property in Tawantin. And at various times, one or the other of them live in different parts of that property. And Wilk starts to object to Headkey's conduct, and he has a solicitor send some correspondence to Headkey proposing that the property be appraised and sold and that the proceeds of sale be divided equally. And then Wilk withdraws that offer and says, no, I'm going to appoint a statutory trustee for sale instead. Headkey goes and gets legal advice, but he doesn't actually make any response to the correspondence with the solicitors, and there's just no more correspondence after that. There's no steps taken to sell the property or to appoint a trustee, and Headkey continues to live at the property for another 2 years until he dies. Once Headkey has died, his legal personal representative springs to action and say, well, actually, the joint tenancy was severed. And Justice Chesterman says, well, the question for the court here is, was there a course of conduct inconsistent with the joint tenancy from which one could objectively infer an intention to hold property as tenants in common? So did they mutually intend to sever the joint tenancy? And that wouldn't require a binding contract to sever the joint tenancy. So the court says, well, it could be an intention to sell, but looking at this particular case, the correspondence is inadequate. There's not even negotiations to sell and divide. There was some letters sent from one side to another that came to nothing, and that correspondence didn't indicate a course of conduct that was inconsistent with joint tenancies. Neither party had acted as though they'd agreed to sever the joint tenancy or sell property and divide the proceeds. So no steps were taken. There just was nothing there for the court to hang its hat on. There's no common intention to sever, and therefore the application was dismissed. Our next married couple are Mario Caruso and Catherine Whitty, and they purchased a property in joint tenancy. And what happened here was that there were substantial negotiations prior to the purchase or prior to the settlement in relation to finance. Now, while the couple got a Commonwealth Bank mortgage, the husband needed some extra funds, and he had 2 brothers and a sister-in-law who are called the siblings in this matter, who loaned him $800,000, which is quite a substantial amount of money. So there were quite a few negotiations. There was a loan agreement between the husband and his siblings, but there was also a deed in which the wife was a party, and there was quite a lot of negotiations in relation to this deed and how it would work, because the wife was very insistent that she have the property as joint tenancy. And what the deed provided for was that if the husband died, or if the husband could, or if he died, his legal personal representative could sell the property, and the wife would have the first right of refusal to purchase. And when the husband died, which of course is what happened, he died owing $924,000 to his siblings. The wife, of course, held a right of survivorship and sought letters of administration of the husband's estate because he didn't have a will. The siblings claimed that the joint tenancy had been severed by the loan agreement and the deed, and that they therefore had a right of sale of the property. through the legal personal representative, and because the legal personal representative was going to be the wife, they applied to the court for an interim administrator to be appointed, and the interim administrator commenced proceedings to resolve the co-ownership of the property dispute. So the legal personal representative is, of course, arguing that the joint tenancy was severed by the deed. And the trial judge agreed. He said the right of sale of the legal personal representative in the deed only made sense if the joint tenancy was severed, and that the deed evinced an intention to hold as tenants in common, not joint tenants. So in equity, legally it was a joint tenancy, but in equity it was really a tenancy in common. The wife appealed. She said, well, no, the siblings knew that this was a joint tenancy. They knew that they would have no security over the property or the proceeds of sale. There was substantial correspondence in evidence which showed that her consistent purpose was to enable the husband to get the loan from his siblings without jeopardising her interest in the property or her interest in the sale proceeds. And that, the correspondence showed that the only thing she was prepared to agree to was a sale in certain circumstances. There was no mutual intention to sever. She was not prepared to agree to anything that impinged on her interest as joint tenant. The deed gave the siblings the power of the sale, but they didn't have any interest in the property or the sale proceeds. So the wife said, well, it is anomalous that they negotiated for a clause in this deed which could, allow the legal personal representative of the husband to sell the property, because, as joint tenant, that would just involve the wife selling the property to herself, which was an anomaly. She says, well, it's not my fault that they negotiated for an amendment to this deed, which didn't help them. So they wanted this amendment. It didn't work. It didn't benefit them. That's not her problem. That doesn't show that the joint tenancy was severed. The Court of Appeal, however, did not agree. So they confirmed that the question that they had to look at was whether there's a course of conduct on the part of the joint tenants inconsistent with the joint tenancy, from which one could infer an objective intention to hold the property as tenants in common. The court said, well, we don't have to find that there is an implied agreement. We're looking for that course of conduct, the course of dealings inconsistent with joint tenancy. They said, well, there is a presumption that with a married couple that you would expect that to be a joint tenancy, and the couple themselves got advice about what registering the property as joint tenancy involved, how the right of survivorship worked. Yes, the siblings knew that the property was being held as joint tenancy. They knew that the husband didn't have a will, and that if he died, it would be the wife that would be the party who would be the one to enforce the covenants against herself. But the Court of Appeal said, well, it's not about whether the deed achieved severance. It's what the deed reveals about what the intentions of the joint tenants were. And the court found that the intention was to enable the husband's legal personal representative to exercise that power of the sale over the property, subject to the wife's right of first refusal. And the court said, well, it doesn't matter if the deed didn't do that. They were told by the lawyer that's what it would do, and that indicated what the intentions were. And the deed would be absurd if the joint tenancy had not intended to be severed, because it would be futile. So the wife had said, well, my lawyers were better than your lawyers. Your lawyers argued for something that was pointless, and therefore you lose. And the court disagreed effectively. The joint tenancy is severed, and the appeal is dismissed in this matter. Our third way of severing a joint tenancy in equity is unilateral severance. So each party or each joint tenant has a right to sever at any time. Now, they may have entered into an agreement not to sever, but that would involve contracts law and breach of contract. But legally, even if you've agreed not to sever a joint tenancy, you can still do it. It's like with a mutual will. If you agree that you're never going to change your will, it doesn't legally stop you doing it. If you change your will, then you breach the contract that you'd entered into not to breach it, and therefore you'd be looking at damages, specific performance, constructive trust, that type of thing as remedies. Each joint tenant can apply to have a trustee for sale or for partition. So usually we wouldn't partition a property because it would tend to, it would tend to devalue that property. So you would usually be looking at the appointment of a trustee for sale where you've got a dispute. Unilaterally, what would usually happen if you had one client that wanted to sever a joint tenancy? It wasn't a mutual agreement where they're filing the same documents. You can complete the required land registry form to transfer the interest to yourself, or to transfer that interest on trust to a third party, which would sever the joint tenancy. But you've got to do everything that's necessary to vest that legal title. You've got to do everything that puts that unilateral severance beyond the recall of that donor. It's in a system of Torrens title, you have to have it registered. And where it's not registered, it won't be effective to sever the joint tenancy because it's possible to be revoked. So we have a couple of cases where this type of thing has happened. So the first one, Lennon and Bell, Queensland case, we have another married couple, John and Pauline Lennon. And in this case, the husband and wife separated. The husband said to the wife, "I've been sleeping with another woman." He proposed that the property be sold and that the sale proceeds be split 50-50. The wife was unwell. She didn't want to deal with selling the property. She didn't want to leave the property, and the husband left the house, and they commenced property settlement negotiations. And just before the wife, whose condition continued to deteriorate, just before her death, her attorney, who was her daughter, served a notice of intention to sever. And she sent that to the solicitor to arrange for service, and the solicitor arranged to give it to the husband, and they didn't receive any response for the husband, and it wasn't lodged for registration until after the death. They did try to lodge it after death, and hence this case. So there'd been no agreement between the couple to sever the joint tenancy, and the wife's children tried to argue, well, there'd been a course of conduct. So the husband had offered to sell and split the proceeds, and the wife had served the notice to sever. So, they said, well, if you look at this course of conduct, then neither of them were acting consistently with a joint tenancy. But the court says, well, no, mostly this course of conduct was the wife's unilateral actions. There were no, the negotiations were ongoing. There was no agreements. There was no inference that the court could draw that they had mutually acted inconsistently with their joint tenancy, and therefore the wife's children failed to unilaterally sever that joint tenancy in that case. Property went to the husband, who was off sleeping with his new partner. Okay, our next case is Goyle and Chandra. So we have another case of marital bliss turning into legal warfare where we have two doctors. We have Dr. Goyle, Dr. Chandra, and they're married. And the husband in this case is trying to get an injunction to restrain the wife from unilaterally severing the joint tenancy over the property. The husband says the wife holds her interest in this property on constructive trust for me because I have contributed so much more to this property than she has. I used to own it with my former wife, he said, and then I had to borrow a whole lot of money to pay her out in that property settlement. And then he married Dr. Chandra. And at that time, he contributed about 50,000 in money to renovate the property, and she contributed somewhere between 75,000 and 100,000 to make these renovations, and they cohabited in the property. And the wife had children from a previous relationship, but the relationship started to break down. Sorry, first the property has been transferred to joint tenancy. They refinance so that each has their own liability for half of the mortgage. So the intention was that they would each separately pay their own mortgages. The husband completely repays his mortgage, but the wife is diagnosed with cancer. She says to the husband, can you please pay my mortgage repayments? You can have the house, you'll have the house after I die. And 2 years later, the relationship's deteriorated to a point where she's left the property and she lodges that transfer to sever the joint tenancy and serves it on the husband, who very quickly goes to commence proceedings to try and injunct the wife's to prevent her from severing that joint tenancy. And when the case is on before the court, the wife is terminally ill. There's quite a bit of urgency on this one. So the husband argues, well, look, there was this understanding. It was a mutual understanding that the property would be held indefinitely in joint tenancy. That's why he transferred it to joint tenancy. He'd made a significantly greater contribution. He said, therefore, there was an equitable obligation not to sever. So again, like many optimists, he believed this would somehow protect his interests without the need for, say, legal documentation or clear agreements. And Justice Brereton said, well, looking at this situation, the husband's equitable interest wouldn't be defeated by severance. So the fact that he has made higher contributions, and that would equal a higher share in equity as equitable tenants in common proportionate to their contributions. And you didn't need to go to the court to prevent severance for that reason, because, in equity, whether or not the joint tenancy is severed or not, he has that argument that because he made higher contributions, that he should be a tenant in common with a proportionately higher amount. Secondly, he repeated what we talked about before, which was that just because there's an agreement not to sever a joint tenancy doesn't actually prevent legal severance of the joint tenancy. If you legally sever a joint tenancy, where you have an equitable obligation not to sever it, then, it's a question of what type of equitable remedy or damages are required. That would be an inquiry for the court, because you'd be dealing there with a breach of contract. Similarly, this could be a case, the court said, of an equitable estoppel, because, the wife said to the husband, I'll pay my mortgage and, pay my mortgage, you'll have the property after I die. And there's probably other evidence as well, but the court said, well, there's clearly a triable issue here that where a joint tenant expects to acquire by survivorship and then acts on that expectation to their detriment, encouraged by the other party, i.e. pay my mortgage payments and to transfer the property to joint tenancy in the first place, then there's a triable issue as to whether there could be an equitable estoppel. And the court said, well, look, we can see the logic here. The husband, having basically paid for the property twice already, probably didn't intend to part with half of the property to the wife, especially when she had children and he had made a larger contribution. The court acknowledged that, it's dealing with real property, so damages would be an insufficient remedy because, it's land and it's been the long-standing home of this fellow. And then the court has looked at, well, we're also dealing with a married couple here. So whatever happens here about whether this joint tenancy is severed or not, it's subject to the family law property settlement regime. And that means that if proceedings are commenced for property settlement orders, the court can adjust the property of the marriage to take into account whatever it needs to take into account. It can take every factor into account effectively when it's making that type of adjustment. So really, the court said an injunction is not going to make any difference to that. An injunction might just be a starting point and really wasn't going to serve any utility. Therefore, the court has dismissed the husband's application with costs. So I think that husband with his terminally ill wife has to very, very quickly commence those family law property settlement proceedings. If he hadn't already, there's no indication in the judgment that he'd already commenced them, and she's terminally ill. So if he doesn't commence them before she dies, so long as he commences them before she dies, he can continue those proceedings after her death. But it's very important. So this was quite a risky, quite a risky position for the husband to be in, considering the claims he wanted to make. Now, our next case is McNamee and Martin, and here we're not dealing with real property. We're dealing with a loan account owned by a family trust. And it's owed to both the husband and wife, John and Margaret McNamee. Now, this loan account is worth somewhere between 4.3 million and 14.6 million. It's quite a difference in variance, but I'm sure there's a reason. It wasn't evident from the judgment from recollection. Now, the court had said a loan is a chosen action, and therefore a chosen action, you can't have a tenants in common of a chosen action. It has to be held as joint tenancy. And the husband, the difficulty they had here was that the husband had a financial manager, so he wasn't mentally competent. And what the wife did was she entered into a deed poll, so a deed where she's the only party, to assign her interest in the joint tenancy to herself in order to irrevocably sever it. And the wife argued, well, look, we've got this deed, but it's not the same as an unregistered transfer in relation to real property. This is a deed that has legal effect when I executed it. And it's, whether or not it's legally effective, we know the court has said that you can't have, at law, you can't have tenants in common of a chosen action. But she argued, well, it's effective at least in equity because equity would prevent her from asserting the right of survivorship due to the deed. So if he died and she tried to say, oh, no, the whole loan account is owed to me now, it could be argued against her that, well, due to this deed, she'd severed that joint tenancy, and in equity should only have an entitlement to half of it. Alternatively, she had an argument before the court that she should be able to, or she was applying for trustees to hold the property, the well, the loan account on statutory trust for partition. She said, well, partition is possible because a shows in action is property under the Conveyancing Act. And Justice Sacker said in this case, well, he considered that the deed had severed the joint tenancy in equity, and also said, well, even if he was wrong about that, then it could otherwise have been partitioned. And this case is interesting because Justice Peden then has a similar type of situation where she kind of revisits these arguments in a slightly different situation. So we have here husband and wife Glenn and Laura Purser, and they own a Glen Davis property as joint tenants. The wife has previously applied successfully for a statutory trustee to be appointed to sell the property, and taking some inspiration, I think, from the McNamee case, she enters into a deed poll to assign her interest in the proceeds of sale of that property. So she assigns it as assign her or an assignee. So she makes that transfer to sever that joint tenancy, and she serves the notice on the husband. And she seeks orders from the court that the proceeds of sale should be divided equally because she has made this deed poll and severed the joint tenancy. The husband, he was there to also make submissions before Justice Peden about what should happen to the sale proceeds, and he said, well, look, they should just be held on trust until a property settlement is determined by the Federal Circuit and Family Court, or there's an agreement between us. Justice Peden said that, next page, Justice Peden said that the parties, of course, had the right to have the property sold and to share in the proceeds of sale in proportionate interest to their contributions. And then she looked at the McNamee case and distinguished it for these reasons. So she said Justice Sacker acknowledged that there was some doubt about the conclusion he had reached on severing a joint tenancy of a shows in action, and was not a situation where the law in that area was settled. She said, well, here also there's a difference, because in that case there was a legal shows in action, whereas here we're dealing with an equitable shows in action. The property wasn't sold, no proceeds of sale existed. And she said, well, this could be an attempt to assign future property, not to assign present right to future property. So the assignment may be incoherent, effectively. She also said, well, you can't assign the whole of a shows in action when you're a joint tenant, and you can't assign part of a shows in action under the Conveyancing Act. She also pointed out that no notice had been given to the statutory trustees for sale of this purported assignment, which is required under Section 12. So she said, well, look, this deed doesn't sever the joint tenancy of the interest under the statutory trust for sale, so in the interest in those sale proceeds. So the wife then argued, well, okay, it's still severed by conduct. There were negotiations for property settlement orders, and the parties recognised that they had entitlements to separate portions of the joint tenancy property, so they put on evidence which had indicated that understanding. And therefore the wife argued that the joint tenancy of this shows in action this equitable shows in action had been severed. The court agreed with that, and the shows in action, or the proceeds of sale would be equally divided. And the court said, look, if the husband's got a problem with that, he can apply for property settlement orders to the Federal Circuit and Family Court to adjust interests between the husband and wife. So we'll now move on to professional responsibility. So what do we need to think about when we've got somebody that comes in to have their estate planning done, and they own property that's joint tenancy, and the estate plan that we're thinking about, or that they're giving us instructions in relation to, involves severing a joint tenancy. So firstly, we've got to remember that we do have a duty to give effect to the client's intentions, and we can be responsible to the estate, or in certain circumstances, beneficiaries who are disappointed if we don't do that. So Hill and Van Erp is where we start with that duty. We should also make sure that we're ascertaining the manner in which assets are owned. This is really critical. So where we have a specific gift in a will, we're expected to make investigations in order to be able to give effect to what our client's instructions are. But I'll also bring up at this point, so we'll look at some cases involving that type of thing, but first I'd just like to bring up another point, which is that you could be there giving advice to your clients. You've got a husband and wife, and for various reasons, usually blended families, they want to sever the joint tenancy, and so therefore they can create a life estate for the surviving joint tenant, and then the capital will go to determined ultimate beneficiaries. Be careful when you're dealing with this, because it may not always be in the best interests of both your clients. So you could have a situation where you've got a younger spouse and an older, and one client's younger, the other one's older and unwell, and you're advising, possibly for other good reasons, to sever the joint tenancy. And then you do that, and then the older person dies, and the younger spouse thinks, oh, well, I would have had this property. I don't think my lawyer acted in my best interests here. I think they were acting in my husband's best interests. Oh, I'm not happy with this at all, and go and make a complaint. So be alive to the possibility that there can be this conflict of interest that might arise when you're dealing with that situation. Make sure that where there is a clear issue of conflict, that you're in writing telling them to go off and get separate legal advice. Where there's less of an issue, they simply, there are extremely good reasons to sever the joint tenancy, and lack of prospects of the surviving spouse to fight that through a family provision claim. Make sure you're still giving written advice. So record that advice. Make sure you're telling them that there'll be reduced assets. If the other tenant dies, then there'll be reduced assets, and they'll have reduced control. Life estates are clunky. But Law Cover does see claims in relation to this type of thing. So just a heads up on that. So we have a case here where the solicitor really didn't see a conflict when it arose. So Legal Services Commissioner in Cass. So the husband and wife are purchasing a property, and they've got a dispute about whether it should be registered as joint tenants or tenants in common. They are using the same solicitor. The husband only agrees to joint tenancy if the wife's granddaughter ceases to live with the couple. He had prostate cancer. The wife just wanted it to be joint tenancy, and they have a meeting. And this is one of those situations where recollections vary about what happened at this meeting. According to the wife, it was agreed that the property would be registered as joint tenants. According to the husband and the solicitor, The husband wanted tenants in common, but would agree to joint tenancy if the wife's granddaughter lived elsewhere, but otherwise it would be tenants in common. So even though the solicitor in his evidence agreed with the husband's version of this meeting, he'd written to the couple after the meeting saying that they weren't in agreement and that he anticipated conclusive instructions on that issue prior to, the settlement. The husband later told the solicitor that the wife hadn't arranged for the granddaughter to leave the property, therefore he didn't agree to joint tenancy, and based on what had happened in the meeting, therefore it would need to be tenants in common. And the solicitor said, oh yes, that all sounds right. The principle of severance would apply. And he said, well, can you send me written instructions, and you should really discuss this with his wife. But the solicitor himself didn't discuss with his other client, the wife. And the husband, of course, writes him an email saying, yes, I confirm instructions to register tenants in common. And the solicitor went off to do that without informing the wife of the instructions he'd received from the husband. The wife had also at this time refused to go to the solicitor's office to discuss the issue. The land registry informed the wife that the transfer document had been altered from joint tenancy to tenants in common, and the wife complained to the solicitor. And in spite of that, the solicitor still persisted to try and register this transfer. And later, the solicitor admitted that he should have realised that a conflict had arisen and that conflict overrode the previous instruction. So he couldn't, it was inadequate to say, oh, well, I was previously told to do that. And, even though they've changed their minds, I'm just going to do what I was previously told to do. That's not how it works. So he ended up with a finding of unsatisfactory professional conduct. He was fined $1,000 and had to pay costs. The Carglin and Friesen's case is a bit of a harsh one, but I can still see how the court ended up where it ended up with here. So we have Nellie Larder, who owns property, and she's got a will leaving that property to her nephew Peter. She later transfers the property, she makes a deed of gift to transfer the property to joint tenancy with that nephew. She then goes back sometime later to the same firm, but there's a different solicitor. She gives that solicitor instructions to give her interest in the property to the niece. The solicitor goes looking for the purchase file, it's not there, the deed of gift file, it's not there, and the title deeds are held by the bank. And so this is England, so apparently they weren't able to do a title search. Anyway, the solicitor prepares the will, presuming that the property is owned as tenants in common, but she does tell the client, well, look, this might not be effective. I can't find the files. There's no deeds. We need to get a copy of the deed from the bank. You're going to need the nephew's consent to do that. And she explained what would happen. She said, look, if you do own it as joint tenancy, then by right of survivorship, nephew will just have the property and the niece won't get any part of it. Solicitor said, if you like, I can go and obtain these title deeds, and the client just ignored that correspondence and just made arrangements to come in and sign the will. While she was signing the will, the solicitor again said to her, we should really check the title deeds. There could be a big problem here. And the client said, that's fine, I'll do it myself. And she didn't, of course, and she's died, and the property was held in joint tenancy, and the niece sued the law firm as a disappointed beneficiary. The trial judge dismissed the claim for negligence, saying, well, look, sorry, the solicitor here didn't breach their duty. They acted competently. The trial judge was happy with that. And secondly, any breach was caused to the estate, not to the intended beneficiary. So the intended beneficiary was the niece, and she was not entitled to any part of the residue. So if the estate itself sued the solicitors, if the duty had been breached, and if the legal personal representative had sued the solicitors, their damages would have been paid to the estate, and that would have been distributed to the residuary beneficiary, so it didn't help the niece. The Court of Appeal said no, they did not agree with either of those things. So firstly, they said a competent solicitor would have advised the need to serve a notice of severance, even if it was tenants in common, that this was integral to carrying out intention. So even if the property had already been owned as a tenants in common, in the circumstances the solicitor was in where there was that doubt, the solicitor was required to serve a notice of severance. In this case, really does come down to the fact that the solicitor was aware that there was this risk, and the court was not satisfied with the way the solicitor had tried to handle that by simply asking the client, to if they could go look at the deeds, that type of thing. In relation to the second issue of double damages, it's quite interesting in this case. They say in this particular circumstance that it's possible to carve out to cut down the interest the legal personal representative would have in any claim by the amount that a disappointed beneficiary would receive. So basically the court's kind of concocted these complementary duties, and we won't go into that because it's not really about that, but that is still an interesting point. So unfortunately for the solicitors on this one, they were found to be negligent. In our next matter, we have a husband who is afraid of his wife, and he's instructed his solicitor to prepare a will which leaves a half interest in a property that he owns in joint tenancy to his children, and to establish a life interest in favour of this second wife. And he doesn't want to serve notice of severance on the wife because he says that will put his marriage at risk. Now, the solicitor comes up with an elaborate strategy of declarations and other documents which contemplate notifying the deceased second wife after he dies, instead of firmly telling the client, sorry, the only way you can do what you want to do is to execute a transfer of interest, to sever that joint tenancy, serve it, and then register it. The solicitor thought his concoction had some prospects of success, but there were none, and he'd left the client with the impression it might work. The solicitor said, look, there is no loss here, there's no breach of duty, because there's no way this client would have served the notice, even if he'd known what the solicitor had come up with was hopeless. The trial judge and the Court of Appeal found on the balance of probabilities the deceased would have served that notice if he'd known it definitely wasn't going to work, which is interesting. And therefore the solicitor is found to have breached the duty of care to intended beneficiaries by providing negligent advice on the severance of the joint tenancy. In Miller and Cooney, the husband and wife already had wills, and those wills were owned by them as joint tenancies, but anyway, in their wills, the wills purported to divide the properties between particular beneficiaries, and this will have been done by a solicitor. And that the husband and wife basically turned up to this solicitor firm at lunchtime. They caught the solicitor at a fairly weak moment, and because it was such a small job of just changing a couple of beneficiaries, so substituting one beneficiary for another in existing clauses of the will, the solicitor took on the job. The wife died, and of course the gifts were ineffective because the properties were really owned as joint tenants, and the wife's beneficiaries claimed against the solicitor for damages for negligence. Pamela Sutter put on evidence that a prudent and competent solicitor would have verified the interest in properties, so done those title searches. But Neville Moses said, look, in this case, that was not part of the retainer. He was just asked to make substitutions to an existing will. He wasn't retained to prepare a will de novo. He was entitled to accept that the question of ownership of the property had been taken into account by former solicitors. The court said, well, yes, we think Neville Moses is correct, that's what's appropriate in this case, that it would be beyond the retainer of the solicitor to check instructions for the previous will. um, when he was just being asked to make minor amendments. And it's really if there'd been any reason, as in the Carglin and Friesen's case, for him to have suspicion, then this decision would have gone the other way. But the court said they simply couldn't see any basis for him to have that suspicion. So they didn't see this as a case where the solicitor was letting a client, knowing the risk, letting the client take the risk, because here there was just no suspicion of risk, and so not negligent. I mean, look, obviously best practice, we always do title searches. I personally would never assume that I would never assume that another solicitor has necessarily got that type of thing right. I would definitely myself be doing those title searches and making sure that you don't want to be in this position. I can see how that particular case happened, and the argument, and that it is quite standard practice, I think, for a solicitor in that case not to have gone to that level. If they turned up with do-it-yourself wills, well, definitely that would have been a different outcome as well. Now, final case is Vag and McPhee, and here we have a separated married couple, and they own a Winmalee property in joint tenancy. They've separated, and the wife's doing estate planning. She's aware that she owns the property as joint tenants, and she doesn't sever the joint tenancy. She makes a request in the will that the whole house be sold and that the husband give the proceeds to their children for their education. But of course, the husband's right of survivorship overrode this request in the will, and that the children say, well, the solicitor owed a duty to us and they breached it because they didn't give effect to mum's intentions here. They didn't advise her to sever the joint tenancy unilaterally, and they failed to take steps to do that. The court said here, well, no, the duty didn't exist. There was no proof that the deceased would have taken those steps if the advice had been given. On appeal, that was upheld. The wife hadn't in the will disposed of particular items, so it wasn't specific gifts to beneficiaries. Instead, the will indicated that she clearly understood it was a joint tenancy property and that it was not going to be part of the estate. Hence, it was the request as a wish. She wanted the whole property sold. And that was just inconsistent with there being a duty for the solicitor to sever the joint tenancy. She was not talking about, I want my half to go here. She put in a request for the whole of the property. And the court also said that you can't assume that she wanted to lose her own right of survivorship. So if husband had died, she would have had the whole property. The appeal was dismissed. So that concludes our tour of severing joint tenancy, and we can see that it's easy to assume severance is simple right up to when it isn't. And sometimes severance is much simpler on TV. Okay, well, I think we will hand back over to Jenna at this point.